Good afternoon, everyone. Sorry for the delay. We had some slight technical problems, but today we're going to talk about Canada's new supply chain transparency legislation. Today I'm being joined by colleagues from across the country, Keith in our Calgary office, Jean-Guillaume and Candice from our Montreal office, and Brendan from our Vancouver office. This is what we plan on covering over the next 50 minutes or so. We expect there's a wide range of familiarity with the legislation in today's audience. Some of you might just be starting to think about this, while others are probably well underway. We do plan to cover some of the basics for those who need an introduction to the law, but we're also planning to dive into some of the deeper issues. We'll start off with some background on Bill S-211, and then get into some detail in relation to what it did, which is creating transparency or reporting legislation and making changes to the customs tariff. Then we'll talk about some of the interesting questions we've been getting, and we'll finish by taking questions. If you do have questions, you can enter them in the QA box using the Zoom QA function, and we'll address as many of them as we can at the end of the presentation. So again, we're going to start with an overview of Bill S-211. So this bill started out in the Senate rather than the House of Commons, like the vast majority of legislation. It was sponsored by an independent senator from Quebec. A little bit of background on the bill, according to the sponsor. So 27.6 million people find themselves in situations of forced labor for many reasons: poverty, inequality, or insecurity. In the senator's words, we are complicit in this through the goods we import and consume. So the intent of the bill was to address this aspect of child and forced labor through supply chains of those companies that do business in or with certain other connections to Canada. It was introduced in 2020, just before the pandemic hit, and the pandemic led to an increase in forced labor with several news stories, which led to some momentum in the government with two parties, the Conservatives and the Liberals, including modern slavery in their 2020 electoral platforms. So I'll talk about this a bit more in a few minutes, but there's currently two main types of modern slavery legislation in the world: transparency legislation like ours, which only requires reporting, and there's also due diligence legislation, which imposes obligations on companies to take steps to eliminate forced and child labor from their supply chain. During the legislative process, this is one of the big points of contention between parties, with some legislators advocating for Canada to take a stricter approach. But in the end, to again borrow some words from the bill's sponsor, the decision was made to not let the perfect be the enemy of the good. So this legislation has been referred to many as a first step, and the legislative process actually reflects this, as not many changes were made during the Senate or the House of Commons. The senators described it as a compromise between NGOs who wanted broader and more severe legislation and the demands of business to take a more pragmatic, gradual approach. And we would also just like, before we get going, we'll note the government has earmarked some funds in the budget for this issue. So it remains to be seen whether or not changes will come. So Bill S-211 received royal assent last May and came into force at the beginning of this month. Even though when we refer to Bill S-211, we're commonly focusing on the Fighting Against Forced Labor and Child Labor and Supply Chains Act, which is the transparency legislation, and which we'll sometimes refer to as FAFL in this presentation. The bill also made some changes to the customs tariff affecting importation. Keith, Brendan, and I will talk about FAFL, and Jean-Guillaume and Candice will talk about the customs tariff. As I'm sure those of you familiar with the bill are aware, there are a few uncertainties in its interpretation, some of which Keith is going to talk about later. And a couple of weeks ago, before the bill came into force, so December 20th, the government, Public Safety Canada, published some guidance on FAFL that clarified some, but not all of these uncertainties. And we will refer to these at a few places in our presentation, this guidance. As a starting point, we need to know what forced and child labor mean in the legislation. It's defined in the reporting legislation, but incorporated by reference into customs law. Legislators specifically chose not to limit to just the convention definition, which you'll see on the screen as B. The convention includes work exacted under the menace of any penalty and for which the person has not offered themselves voluntarily, and then provides certain exceptions to this. So the legislators expanded to also include situations where the person believes their safety or someone else's safety would be threatened if they don't perform the work. One thing to note here, when we think about forced labor, we often think about things like Uyghur labor in China, but it should be kept in mind that some of this can happen closer to home. For example, this often comes up in the context of seasonal labor in both Canada and the US. For child labor, again, legislators chose not to limit the definition to the convention. So the convention, which is D here, includes labor that's similar to slavery, prostitution and pornography, illicit activities, in particular those related to the production and trafficking of drugs, and those likely to harm health, safety, or morals. So our law expands to include situations that are against employment laws. So this is another example where we should look at home as well, under circumstances that are mentally, physically, socially, or morally dangerous to the child, or that interfere with schooling. To put our law into context, around the world, as I mentioned earlier, there's reporting legislation in Australia and the UK, California as well, and then there's due diligence legislation, which requires companies to actively investigate their supply chains. So this is in place in countries like France and Germany. There are also import bans, which I believe Jean-Guillaume is going to talk about a little bit later. So for example, the US has laws banning import of certain products from certain regions due to concerns about Uyghur labor. Some quick differences between our law and the UK Australian law. Our law covers smaller business sizes. They did try to harmonize to make it easier for companies to comply with all three sets of legislation at the same time. And there are a few other obligations which we'll discuss later, like an obligation to send to shareholders in certain instances. At home, we have CORE, which is the Canadian Ombudsperson for Responsible Enterprise. So that organization is tasked with investigating these issues, specifically in the textile and mining industries. You may have seen some decisions from them recently. Class action lawsuits, for example, consumers might be saying that they were influenced to buy products because of statements made in relation to modern slavery, and commence class actions if they don't believe these statements were true. This leads to freedom washing, which is similar to greenwashing, where the Competition Bureau might take an interest. They haven't yet, but they might take an interest in statements made. The criminal code has certain provisions on trafficking in persons, certain exploitation provisions, kidnapping, extortion, forcible confinement, and we could also have some obligations under trade agreements. So Brendan and I are going to talk about what the transparency legislation includes. So the first step is to figure out if it applies to you. I'm not going to spend a lot of time on this. This is one area where our law differs from the UK and Australia. Heads of government institutions have to report on what they do. More relevant to the people on this call, any entity that produces, sells, or distributes goods anywhere in the world, or that imports goods into Canada, has to report if they meet the definition of entity, which we'll get to in a second, or anybody that controls an entity that does one of those two things. So an entity is a corporation, trust, partnership, or other unincorporated organization listed on a stock exchange in Canada, or that meets certain thresholds, which we'll get to, or prescribed by regulation. At present, there's nothing prescribed by regulation. So private companies or those not listed on Canadian stock exchanges, we have to think about these threshold questions. To start, the company has to have, or the organization has to have a place of business in Canada, do business in Canada, or have assets in Canada. This is something we've had a lot of clients come to us to help on assessment of. And they have to meet certain thresholds. So Keith is going to talk about this a bit later, I believe, but these are worldwide numbers. You have to have met 2 of the following conditions in at least one of your 2 most recent financial years. So to have 20 million in assets, again, worldwide, generated at least 40 million in revenue, and employ an average of at least 250 employees. So I'm going to hand it off to Brendan now, who's going to talk about some of the filing requirements.
Thanks, Ian. So with respect to filing requirements, reports are due on May 31st of each year in respect of an organization's most recently completed financial year. And to comply with the Act, a report must meet the 4 requirements you see on the screen. First, the report must include information addressing each of the legal requirements set out in the Act. Report must also have received the required approvals and include a signed attestation. This attestation is set out in the guidance. Third, the report must not exceed 10 pages in length or 20 for reports provided in both Canadian official languages. Fourth, the report must be a PDF file not exceeding 100 megabytes in size. And the report must be accompanied by a completed questionnaire, which we'll talk about on a later slide. Now, with respect to the length restrictions in particular, we've now been made aware that notwithstanding the current guidance, the 10-page limit is actually a suggestion and not a hard and fast rule, and that we should expect updates to the guidance in this respect. That being said, of course, the size and length restrictions are certainly something that entities, especially those with existing reports, should be aware of. One question that's come up a number of times is the submission of a joint report, and the guidance included some helpful information in this respect. So entities are expressly permitted to submit a joint report covering its own actions and those actions of any entities it controls, or a report that covers multiple entities belonging to the same corporate group. Now, the guidance says that a joint report should only be submitted where information provided generally applies to all of the entities covered by the report. And the report itself should specify which information applies to which entities. In addition, the guidance does say that a joint report should not be submitted in cases where entities have risk profiles or policies, or have taken actions that diverge significantly and in a way that would make it difficult to prepare a report that accurately describes all of the entities. Now, moving on to what information must be included in a report. The substantive requirements for what needs to be in a report can be found in sections 11.1 and 11.3 of the Act. And the required information fits into 2 main buckets. First, the report must include a description of the steps taken during the previous financial year to prevent and reduce the risk that forced labor is used at any step of the production of goods in Canada or elsewhere by an entity, or in the production of goods imported into Canada by that entity. And the second bucket, the report must also include prescribed supplementary information set out in the Act. And this includes information pertaining to an entity's structure, activities and supply chains, its policies, and its due diligence processes in relation to forced and child labor, as well as the parts of its business and supply chains that carry a risk of forced labor or child labor being used, and the steps that it's taken to manage that risk. As well, entities need to include the measures taken to remediate any forced labor or child labor, information concerning the training provided to employees, and importantly, how the entity assesses its effectiveness in ensuring that forced labor and child labor are not being used in its business and supply chains. Now, it's important to note here that the guidance provides very helpful information under each of these headings and includes detailed suggestions as to the type of information that should be included. But that being said, there's no prescribed level of detail required for the responses, and entities should use discretion in determining the appropriate level of detail proportionate to their size and risk profile, while of course respecting the specified size and length requirements for the report. Now, the guidance does say that entities are expected to provide honest responses, that describe the concrete actions they've taken and discourages the use of aspirational statements. As Ian mentioned, this legislation at this point is viewed as a first step. And we spoke with Senator Julie McGill-Deschênes, who was the sponsor of the bill, and she stressed to us the need to meaningfully engage with the reporting requirements. Now, a bit more on the substance of reports. So reporting entities are encouraged to use simple and clear language in their responses and are encouraged to explain unfamiliar terms in order to make the report as accessible as possible. In addition, entities are permitted to include information supplementary content in the report, including charts and graphs, and are permitted to include links to relevant websites and publicly available documents. This includes things like public disclosures or statements by the entity, and even applicable risk assessment or supply chain reports. Finally, there's no requirement to disclose commercially sensitive information or information pertaining to specific cases or allegations of forced labor or child labor. Now, with respect to the questionnaire that I mentioned briefly on a previous slide, each report must be accompanied by a completed online questionnaire. The requirement to file the questionnaire was actually introduced by the guidance and is perhaps the most interesting development coming from the guidance. Now, this questionnaire includes both mandatory and optional questions. Some mandatory questions simply identify information about the entity, such as its financial year for which the report is being completed and the sector in which the reporting entity operates. And other mandatory questions collect information needed to comply with each of the Act's reporting requirements. Those are those two buckets of information I touched on the last slide. Now, these questions are followed by optional open-ended questions that allow entities to elaborate on their responses. It's important to note here that the questionnaire may be used as a report template or guide for developing reports. And the guidance even goes so far as to say that entities can use the exact same information and structure provided through the questionnaire in the preparation of their report. We think that this might be helpful to entities who are concerned about the administrative burden of preparing a report, but again, refer back to the requirements that the report meaningfully engages with the legislation. And so, entities that might have increased risk should consider doing more, of course, than just the bare minimum. Now, moving on to the next slide, where does the report go? Once a report has been completed, an entity required to file the report must file it with the Government of Canada via the Ministry website. Must also make the report publicly available, including by making it available in a prominent place on its website. And if it's a CBCA corporation, provide its report to shareholders along with its annual financial statements. Keith is going to touch on this briefly later on in the presentation. Now, importantly, and this question has already come up, if you do not have a website, you don't need to get one for this purpose, but entities without websites should be prepared to provide a copy of the report to any member of the public who requests it in writing. Now, with respect to enforcement of the Act confers investigative authority upon individuals designated by the minister, and the minister possesses wide-ranging powers to compel an entity to undertake any actions deemed necessary to ensure compliance. We've included on the slide here some of the main offenses under the Act, which include neglecting to prepare or publicly release a report, refusing to cooperate in an investigation, obstructing an ongoing inquiry, disregarding a corrective order, and supplying false or misleading information. And note that these offenses are punishable by potentially summary conviction and a fine of up to $250,000. So I will then pass it off now to Jean-Guillaume and Candace, who will speak a little bit about the customs tariff.
Thank you, Brandon. So moving on to the import prohibition rule. So obviously, I think it goes without saying that the first measure that should be taken in order to fight against forced or child labor within supply chains in Canada is obviously to ensure that goods produced in this fashion actually never enter domestic commerce in the first place. So in Canada, the legislative tool that the Canada Border Services Agency can use in order to enforce the import prohibition of these goods. That's basically the customs tariff and more precisely the application of tariff item 9897. So prior to January 1st, 2024, the import prohibition rule only covered goods that were mined, manufactured, or produced by forced labor, but there was no specific definition used for that purpose. Historically, the import ban was originally enacted back in 2020. That was right after the ratification of the Canada-United States-Mexico Agreement, or CUSMA. If you recall, this was the free trade agreement that replaced NAFTA. So under the new agreement, it provided for an obligation for each country to include, as part of their domestic legislation, the import prohibition. So that's why Canada amended the customs tariff to include the prohibition under tariff item 9897, and this was effective as of July 1st, 2020. Now, since January 1st, 2024, the new amendments to the customs tariff, they now include an extended prohibition on the importation of goods, that time not only produced by forced labor, but also by child labor. And the import prohibition rule, it also now refers specifically to the definitions of forced labor and child labor as they used in the Act. So what it means in practice is that importers basically would probably face a greater risk of violating the import ban. Just based on the fact that the extent of the goods that could be subject to such prohibition has actually increased. So I will now give the floor to my colleague, Candice.
Thanks, Jean-Guillaume. So since July 1st, 2020, when Canada first implemented the import ban, they also gave the Canada Border Services Agency, which I'll refer to as the CBSA, increased powers to enforce this ban. These powers include the detention and examination of goods at the border, the seizure, destruction, or disposition of prohibited goods, the application of ascertained forfeitures, which basically means that they will apply a monetary penalty in lieu of seizing actual goods, for example, when they cannot be seized. They're also able to search property of persons in question, apply monetary penalties that would be in addition to any penalty applied on the ascertained forfeiture, and even criminal prosecution. What should be noted is that the Canada Border Services Agency is not limited to enforcing this import ban against the importer of record as indicated on the Canada Customs Coding Form, which is the B3 form. Rather, the CBSA can use its powers after the goods have crossed the Canadian border and have been transferred to third parties. So what this means in practice is that technically a CBSA officer can force an end user like you or me, who, for example, purchased clothes that they believe was produced in part by forced labor, to forfeit these products that we had already paid for. So this may seem like broad powers that are granted to the CBSA, but they can only act if they have reasonable grounds to believe that either forced labor or child labor was at least partially used in the production, mining, or manufacturing of the goods in question. And although this is in line with Canada's legislative landscape, it seems to be limiting the CBSA's ability to act. So let's take the United States, for example. In the United States, the Customs Border Patrol, the CBP, has a rebutable presumption that any goods that were imported from the Uyghur region, the Xinjiang region of China, it's with respect to these goods because of the alleged forced labor of the Uyghur people in that area. So what this means in practice is that goods that are brought to the US border from this region of China are prohibited from entering unless they provide clear proof that the goods in question were not made by forced labor or child labor. And situations have even occurred where persons have tried to import goods into the United States, they have been stopped, and they subsequently try to import these goods into Canada. Another example of the difference between the Canadian government and the United States government has to do with the importation of personal protective equipment from Malaysian suppliers. So there are two instances where the United States specifically prohibited these importations from these Malaysian suppliers. And one of these suppliers actually had a contract with Public Services and Procurement Canada to provide medical gloves. So obviously, upon allegation of forced labor practices that were brought forth by the United States, PSPC did first put the contract on hold, and then they eventually canceled the contract. But contrary to the United States, the Canadian government never formally banned imports from these Malaysian suppliers into Canada. So now we'll go to the next slide. Thank you. So basically, since May 2023, when the brought-in import ban was announced, the CBSA has been under even greater pressure. But for the reasons that I mentioned previously, it's been very limited in its success to implement same. In fact, there has only been one instance where the CBSA has managed to seize importation of a package at the border on the grounds that they believe that the goods in question were made by forced labor. And this was in November of 2021, and it involved the import of children's clothes and women's clothes from China. However, upon further review, in the winter of 2022, the CBSA was forced to release the goods because the conditions to respect the import ban were not met. So the CBSA's limited success in enforcing the import ban has really had certain advocacy groups demanding increased measures that Canada implement in the fight against forced labor. And Jean-Guillaume is going to discuss one of these such examples.
Thank you, Candice. So just to give you an idea of what's likely coming in terms of public pressure to enforce the import ban, there is this interesting court case. So what happened in this case is that that was shortly after the enactment of the import ban I discussed earlier. That was in July 2020. So there was an advocacy group fighting against, in that case, it was the Uyghur forced labor. So they wrote a letter to the CBSA to request that they put in place a presumption that would essentially prohibit the import of all goods originating from the Xinjiang region in China. And of course, this was on the basis that these goods would have been produced by forced labor. And in fact, the request was essentially a copy and paste version of the rebuttable presumption used in the US that Candice just discussed. So in January 2021, the CBSA sent an email, a response to the group, and they basically stated that the CBSA simply doesn't have the authority to either prohibit or regulate goods for production by forced labor, and this strictly based on the fact that such goods originate from a specific region or country. So obviously, the group was not satisfied with the response, and in February 2021, they filed an application for judicial review on the basis that the CBSA erred in law when stating that they do not have the authority to apply the presumption as they requested. So here, the federal court dismissed the application, notably because, according to the court, this was not a matter that could be subject to judicial review. And even in the context where this matter would have been justiciable, the federal court was also of the view that the CBSA's interpretation of the customs tariff was all in all reasonable. So again, the group filed an appeal from the federal court judgment, So at the Federal Court of Appeal, the group's appeal was also dismissed. And the court ruled that the CBSA response was only a courtesy reply, basically explaining the CBSA's views on how the import prohibition and the investigation process by the CBSA basically work. And accordingly, this was not a response, the email, that could be subject to a judicial review application. Now, as the group does not seem to be willing to take no for an answer, they ultimately file an application for leave to appeal to the Supreme Court of Canada. I believe it was back in November. Obviously, I would say that the application is unlikely to be granted, but I believe this gives you a pretty good illustration of how far an organized advocacy group is prepared to go strictly to push their agenda. So I now pass it on to Keith.
Thanks, John Gillum, and to my fellow presenters so far. Look, we've spent a lot of time giving you sort of the lay of the land of the legislation, as we should. I'm going to come back to different aspects of the legislation and sort of focus on some points where I think there's confusion. Some of these have been partially resolved by the guidance that was released, as Ian and Brendan referenced. But there's still, I think, some issues where it's worth highlighting, and to the extent we can offer incremental guidance based on our views and as sort of supported by the guidance, or at least benefited by the guidance in certain ways. So the first aspect of that is just going back to first principles, which is, where does this obligation to comply with the act come from? Well, it comes from being characterized as an entity. And as Ian and Brendan said, a couple of mechanisms of determining that. You have a listing, or you have a place of business, do business, have assets, and you exceed a certain threshold. Seems simple. The plain language reading of some of those words would seem obvious on their face. Having assets in Canada seems fairly simple. So does having a place of business in Canada. But what's interesting in the guidance is they actually expanded the potential for what a place of business is in Canada, beyond simply owning or leasing land or a property, commercial property to conduct a business, to also including even if a space is made available to you for the purpose of conducting business, which is interesting and potentially expansive in terms of having the entity test be satisfied by a particular issuer. But the one that I think is the most challenging is the doing business in Canada. And we've had a decent number of international issuers who are not primarily conducting their business in Canada, who query what that actually means. Because unfortunately, there are no definitions in the legislation, FAFL as I refer to it, and you're forced to look elsewhere. And thankfully, the guidance did provide some parameters for that interpretation, advising people to look to the CRA guidelines and quote the ordinary sense of the words in trying to assess if you're doing business in Canada. And there are a bunch of criteria under those CRA guidelines that one can point to. They're very expansive, however, and there's no de minimis element to those words. And so, you could find yourself technically under the legislation having no place of business in Canada and doing only a marginal amount of business in Canada. A simple and exaggerated example would be you do $1 billion of business outside of Canada and you sell one widget to one customer once a year, and you could be doing business in Canada without a place of business in Canada. So it's potentially very expensive in terms of who it grabs. Now, they did provide some very subtle comfort in the guidance by providing that very minor dealings, in their words, would not satisfy the test. But again, you're left with a very subjective measure that each individual issuer is going to have to test against their risk tolerance for potentially getting it wrong and being revisited by the government of Canada after the fact. So that'd be the first point. I think the second one would be when we're looking at what an entity is, as Ian earlier articulated, it's described in the legislation as a corporation, trust, partnership, or other unincorporated organization. What's not there is contractual joint ventures, for example, who would not fall within those parameters. So you could have yourself in a rather odd situation where if you have a corporate or a limited partnership joint venture, that could be an entity in and of itself, depending on whether it satisfies the financial and employment thresholds that we've articulated. As compared to a contractual joint venture in the exact same circumstances with the same assets and same business, not having an obligation because it's not considered an entity. So just bearing that in mind in your structuring, with respect to a contractual JV, you're going to find yourself in a situation where the joint venturers themselves are going to have to test whether they're an entity and what they do with the assets, businesses, et cetera, that are confined to that contractual JV in calculating their own thresholds for reporting. And it may be that in certain joint venture situations, you end up with a circumstance where the joint venture entity, this is in the context of corporate and limited partnership joint ventures, the joint venture has a reporting obligation as an entity in and of itself. And then one or more of the joint venture partners may also have reporting obligations. And the way that they've defined control for purposes of FAFL is quite expansive and not terribly helpful. I mean, it has a look-through aspect to it through direct or indirect control. So a subsidiary of subsidiary is going to be captured if that's indeed the case. But, it's unclear whether it's the corporate standard, which would sort of be, sufficient voting securities over 50% or something else, which will require some interpretation for the time being. There may be further guidance that comes before the reporting timelines are triggered. But until then, we're going to have to use just good judgment to try and assess who has these obligations. The next, again, I just want to emphasize, and I touched on in the first slide, is the de minimis question, which is to say, as both Ian and Brendan noted, the entity test is measured on a worldwide basis, worldwide revenues, worldwide assets, worldwide employees. And so it may be that the Canadian connection is very small, and that doesn't matter for purposes of assessment of the entity. Another point that I see is brought up in the chat, and we'll try and get up to all the Q&A questions shortly, is, what are goods and do goods include services? There are other modern slavery legislative regimes around the world which are clear in articulating that services are included. The legislation here is very clear that it's goods, and in the guidance, they've tried to provide some comfort that it's, goods that are subject to trade and commerce, in giving some comfort that services are not there. And in fact, they've articulated further guidance that say that even services that are there to support production, sale, distribution, importation are not intended to be captured either. So I think that answers one of the Q&A questions, and we'll try and get to the rest as fast as we can. The next point I'd like to discuss is the treatment of affiliated entities. And I think one of the Q&A questions touches on this as well. And I just want to make sure people appreciate that the assessment of the entity doesn't necessarily determine whether or not the ultimate parent is going to have an obligation to kind of look at that entity and include it in its own report. So to that end, if a subsidiary is not an entity, so it on its own and with its subsidiaries, downstream subsidiaries, it doesn't qualify for the threshold tests. Technically, it does not have a report obligation, but that doesn't necessarily mean it's irrelevant. You can forget about it in the context of the parent reporting obligation to the extent it is an entity and has an obligation. Because recall, this entire legislation is directed at supply chains. So to the extent a parent is simply a holding company and uses its subsidiaries to conduct its business, you can't find yourself in a situation where you can dodge reporting on entities small e, just because they don't technically in and of themselves qualify as an entity. They are part of the supply chain if they're part of that production, distribution, sale, importation process. And they'll need to be incorporated in the dialogue for the parent report at the very least. And then I guess yeah, I mean, that largely summarizes the point I was trying to make in that one. The last topic I want to talk about is, I think, the one that comes up the most when we talk to our public company clients who are CBCA issuers. And, you know, I have to admit that the drafting in the policy isn't terribly, or in FAFL is not terribly helpful in this respect. What they have done, to be clear, is in addition to the obligations that are imposed on all other entities by way of reporting and posting reports to websites and publishing through the portal along with the questionnaire, is to say that CBCA companies must, and I use the words advisedly, provide to their shareholders along with their annual financial statements the report. There are no definitions of what provide means or along with. There's no guidance been given to date on those topics. We certainly hope that there will be, because I think if there's one area of significant uncertainty based on the drafting, it's this. We've had some dialogue with the CSA, Canadian Securities Administrators, with respect to this and its interplay, if any, with the securities law obligations to mail financial statements. They generally are taking a hands-off view, and I think rightly so, because it is not a securities law obligation, and it shouldn't be regarded as compromising or changing your securities law obligations with respect to the delivery of financial statements. The challenge that creates is that, you know, first of all, there's a timeline under the legislation that ostensibly gives you to May 31st to prepare and file a report. For many issuers, the financial statement delivery obligation is significantly in advance of that. And so you're left with something of a conundrum in terms of recognizing you have a significant amount of time to prepare the report, but the obligation to provide it along with financial statements. So with the issuers that we're talking to, you know, it seems like a lot of issuers are going to adopt the approach of preparing the report early so that they can deliver it at the same time that they actually are intending to send the financial statements. It doesn't, in and of itself, and I want to be very clear, the obligation to send financial statements doesn't accelerate the report timing. It's a question of convenience and whether or not that's the way to satisfy the FAFL obligation. Or, I mean, theoretically, you could find yourself in a situation where if you want to delay your report to May 31st, that's great. But to comply with the legislation, you'd be sending financial statements again, which doesn't seem to make a lot of sense either. So, as I said, there's no guidance in this respect. The pragmatic approach, which I think people are going to come to, if not this year, then in subsequent years, and hopefully with guidance, is that if you're an issuer who's already, as a CBCA issuer, getting relief to enable you to use the notice and access delivery approach for proxy-related materials and annual financial statements, you're going to adopt a similar approach with respect to the provision of your report. And the word provide, I think, is helpful in that respect. It doesn't say mail to, it doesn't say send to your shareholders, it says provide. And it says along with. So if I'm sending a notice and access notice to my shareholders to let them decide if they want a mailed out copy or if they're fine just accessing the website, if I send them a notice along with that notice and access notice, giving them the same opportunities with respect to that report, I think from a practical perspective, it's addressing the objectives of the legislation, certainly the spirit and intent. And I think you can get there with the language as well. But I think in this first year, we're going to see a lot of issuers taking a lot of different approaches depending on their particular circumstances and their risk tolerance. Sorry for being a little long-winded. I'll pass that back to Ian to carry on.
Great, thanks, Keith. So it talks a lot about what the legislation requires, and as we said earlier, it doesn't actually require you to take any steps in relation to forced and child labor in your supply chain. It just requires you to be transparent about what you're doing and report on what you're doing. But these, as we've discussed, these reports will be made public. So we're also getting a lot of questions about what sorts of things companies can be doing to talk about in the reports. So in the next minute or so, I'll run through some of these, and then we'll move on to the questions. So some of the things we've come up with, the first thing to do is to conduct a self-audit to see what you might already be doing. Many companies, surprisingly, when I speak to people, they haven't thought about this, but then when you dig down on like, do they do certain things? Like, do they have supplier codes of conduct? Do they put things in their supply agreements? They actually do already have some measures in place. So a self-audit is the first step. Other things that can be done is to have internal policies and training, teaching people in your organization to report on to how to recognize risk of forced labor in the supply chain, conduct audits of suppliers, send questionnaires to suppliers, things like that. As I mentioned earlier, you can have commercial terms and supply agreements and or include it in your supplier code of conduct if you have one. Also potentially relevant in the M&A space, if you're doing diligence on a company that you're considering acquiring, this can be included in the diligence process as well as in reps and warranties in the purchase agreement. And finally, if you have identified any risk of actual forced or child labor or any instances of child or forced labor, have policies to address this, including remediation efforts. So this is another spot where the Canadian legislation differs from Australia and the UK. There's a requirement to talk about what you're doing in relation to remediation. So this is a recognition that in some countries, families or individuals may depend on, for example, child labor to get by. So what steps are companies taking to help mitigate and offset the removal of child and forced labor from their supply chains? And then, of course, from a practical perspective, have to think about the things Keith was talking about, the timelines, make sure that this does have to be approved by your board. So, let your board know it's coming, ensure there's time built into your process to get approval. So those are a few of the things we've thought about, and we've been working to develop some resources. So please feel free to reach out if you'd like to discuss any of these things. So now we're going to move on to questions. Bear with me on the technical part of this. So the first question we have is, can you include initiatives you started in 2023 but won't be completed until 2024? Or should you only include information once it's being completed? I'm not sure if anybody on the I can handle this, or did anybody else on the panel? I'll go ahead then. So the report has to be about activities in your financial year. If you've started to undertake activities, then I think they can definitely be discussed. Ideally, you don't include sort of aspirational statements, but you can talk about, for example, having conducted gap analyses, having anything you've started, definitely, like we've started developing a policy, we've started working on, but it has to be accurate and reflect what you did during the fiscal year. Another question, when we're counting employees to see if we're big enough to be covered by this legislation, do we count part-time workers the same as full-time? And what about independent contractors? The guidance is quite helpful on this, that the answer to the first question is yes, you would include your part-time employees. And no to the second one, you don't include independent contractors. We're also getting many questions about the requirement to report by services, and this is definitely one of the things that we had been hoping to see clarified in the guidance on what constitutes a good. There's a lot of things in the gray area, software, other products like that, health tech, and that is that requires a bit of a risk tolerance assessment as well as a case-by-case assessment. Unfortunately, we don't have a bright line answer for that one. We would love to. This is, again, like I said, this is one of the things we were really hoping would be addressed in the guidance, but it wasn't. Another question, which maybe I will hand off to Brendan. I'll read the question. You mentioned the guidance can mirror the questionnaire and be high level. When would you advise clients take the high level approach versus when would you advise that they include more detail?
Yeah, thanks, Ian. So I think that in instances, as I think I mentioned, where there is, or I guess, or at least a perception of increased risk, whether that's because the goods are coming from places where forced and child labor is known to be used, or their goods, I guess, that are known to be produced with forced and child labor. I think that that's where our advice is to provide sort of more details and not just to take the high level approach. Of course, and I think Ian mentioned this, in instances where entities are filing voluntarily or just sort of out of an abundance of caution and really don't think that there is risk, then perhaps the more high level approach is appropriate. But and I think the guidance uses this language. It's all sort of about proportionate to the risk profile of an entity.
Great, thank you, Brendan. Another question, the law provides the report must be approved by its governing body. Could this be a single board member, or does it have to be the whole board or an executive?
Sure, happy to answer this one as well, Ian. The guidance specifically refers to governing bodies. And so I think that to the extent you're going to do a written board approval, then consent of the whole board, or otherwise if it's at a board meeting, then whatever the required threshold is for approval.
Okay, another question we got is it possible to receive the presentation or access the recorded meeting? And the answer to that is that we will send a link to the presentation, which I believe includes a recording, to all participants afterwards. One more question. What do we expect the approach to enforcement to be, and whether or not we think there will be fines in the first year? I can take this one. So we spoke to the senator who sponsored the bill, and we've also been to some webinars put on by Public Safety Canada, and in both cases they've indicated that they'll take an incremental approach to enforcement, which suggests to us that at least for the first few years the government's going to sort of work with people to bring them into compliance rather than slapping fines. This is not a guarantee, but it's what people have been saying. As Brendan mentioned earlier on, there are a few different scenarios where fines might come into play, and there might be some higher risk of fines with some things, like if your report contains misleading or fraudulent information, that might be more likely to attract a fine in the first couple of years. But other things like the structure of the report, some filing details, things like that, we sort of expect that the approach is going to be more like requesting that you file rather than any fines. Although again, this is not a guarantee. It's our feeling based on the discussions that we've had.
Ian, I might jump in just briefly to add to that. Based on, I think some of the people on the call will recognize that a lot of the language seems to have been borrowed from the Government of Canada's similar approach as it related to extractive sector transparency measures reporting that commenced a number of years ago. Similar potential punishments, similar sort of reporting obligations. And in that circumstance, for those of you who've had to file those in the past, certainly for the first number of years, notwithstanding the potential for financial penalties, the regulators were very much focused on just getting it right. And so you would get comments back from them if they thought a report was not representative of what they were seeking and allowed to refile. And certainly the legislation here contemplates the potential to refile your reports. And so I think my expectation would be they'll follow a similar path, which will be in the first year or two, really trying to help you get it to where they think it ought to be.
Thanks, Keith. So we're running out of time, but our final slide, this is the contact information for all of the presenters today, and all of the presenters are also the key contacts from each of our major offices offices. So Candace and Jean-Guillaume in Montreal, Keith in our Calgary office, Brendan in our Vancouver office, and myself in our Toronto office. So if you do have questions that we didn't get to today, or if you'd like any assistance with implementing measures that you can talk about in your report, or drafting the report, deciding if you have to file, things like that, we are more than happy to help you out. So thank you for attending today, and thanks to our other presenters.